But allowing somebody to drill or put condoms in tanks isn't protecting me if you're going to do it in my floodplain bottom. That's no protection. Protection for me would to have them do it somewhere else. You know, I mean, I realize that's taking it to a whole other level, but, you know, they're really, you know, you're going to tell them, well, go ahead and build up that floodplain. Well, if they build up my floodplain, when those floods come, it's going to force more water to erode the bank in front of my house. Right now, my house is not in the floodplain, but my bottom meadows are. But the creek does come in front of my house, and I've been here long enough to see the power of that water and what it can do. And building up a floodplain just makes it worse for people upstream. It'll make it worse for in front of my house, where all that much more water will be coming. Yeah, right. Well, that would be on me. And in the financial protections, if you allow somebody to drill in my bottom and my bank erodes to my house, are the commissioners going to pay to shore up my bank? In section F about reduce financial burdens imposed on residents and its governmental units by preventing the unwise design and construction of development in areas subject to flooding. What does that mean?
I'm not sure where you're at, but I'm thinking it
It's
means...
under intent.
What page is it?
Section 1, intent.
Oh, okay.
F, under F.
Is that not one of the issues that Mr. Williams has received?
I don't know. Not about this particular section.
I have my problem with the question.
Well, I said under section 1, intent. On F, under F. A is promote the general health, welfare, and safety. F is reduce financial burdens imposed on the residents and its governmental units by preventing the unwise design and construction of developments in areas subject to flooding.
I think that's pretty self-explanatory.
Well, what I'm asking is, if you allow any gas company to drill in my bottom, raise that floodplain up, which is going to cause the water to erode the bank in front of my house much faster than it already is. Or is the commissioners going to pay to sturdy up that bank, or is that going to be left on me because you guys said it's
had that detrimental occurring to start with.
Well, you couldn't if you allowed them to drill
Well,
there. You
they're going to have to submit a study. They're going to have to prove that they're not going to do that before they can ever come in there and start there. So hopefully we're eliminating that before it ever happens.
Okay, sir, go ahead.
My name is Steve Hastings, and I'm with the law firm of Hendrickson & Long.
Speak up.
Some of you may know me. Some of you may know me a little better than others. As the ones that know me know, that we represent EQT Production Company, and we represent them in the issues with Mrs. Huff and with the County Commission. And we, as Mr. Tennant will tell you, Mr. Wellens, we provided numerous comments to the various drafts of the floodplain ordinance. I do want to begin and echo the comments that Mr. McMahon stated, and we thank the County Commission as well for attempting to make a sound ordinance. We appreciate that Mr. Schneed's here. We appreciate that Mr. Tennant has stayed on board after the litigation to help with this. Before this case, I probably didn't know much about floodplain ordinance either, and I know a lot more now than I ever probably wanted to. And Don, you probably say the same thing. We understand the primary issue is to make sure that the property and the citizens of Doddridge County are protected in the event of a flood. We recognize that. I want to make sure that you guys understand that that's why we're participating, to make sure we have a sound ordinance. And with all due respect to Mrs. Huff and getting into semantics, We lawyers play semantics all the time, that's what we do. It is our position that the Circuit Court of Dodgers County ruled, and the effect of his ruling was that the Dodgers County floodplain ordinance previously in existence is unconstitutional. Instead of going out and drilling the wells that we had properly permitted with the DEP, we chose to stand down and to work with the county to help enact an ordinance. And everybody, I want you guys to listen to what I'm saying to you. Instead of going out and doing something, we want to work with Dodgers County to make it right. But you also need to understand this. What our comments are directed toward are not just for the oil and gas industry. Now, if Mr. Tennant and the Commission publish all the comments, you'll see a lot of those comments are not directed just to the oil and gas industry. They're to protect farmers, homeowners, different industries other than the oil and gas industry. One way of looking at this, it may say, well, we're just here so we can put wells in the ground. That's true, we want to drill. There's no question about that. That's what my client is in the business of doing. But you also have to understand, you may want to build an addition on your garage that would be directly affected by this. You may want to build a barn in your field, which is directly affected by this. These are things that everyone needs to pay attention to, because once this ordinance is enacted, this is not an ordinance directed to the oil and gas industry. The DEP regulates that. This ordinance is going to affect everyone in this room. So that needs to be in the back of your minds when you understand why I'm saying some of the things I'm saying and some of the comments that we made. We reviewed the most recent draft, and I understand there's a fifth draft ongoing. We think there are still some serious constitutional issues in the fourth draft. And regarding that draft, we appreciate the fact that many of our comments have been incorporated in the document. I don't think anybody's going to dispute with some of the things we say. We're trying to make it cleaner. I was pointing out some of the typos of Mr. Tennant. This should be an A as opposed to a 1. This should be a 3 as opposed to a C. Don probably got tired of some of that information, but we're trying to make sure everybody understands if there is a legal battle later, that we are on the same page and we all know what we're talking about. Unfortunately, because there remain several substantial issues with this floodplain ordinance, it's our position that if the ordinance as drafted is enacted, there will be a constitutional challenge and it will be ruled unconstitutional. And all that will do is delay, have FEMA breathing down Mr. Sneed's neck further to get on the county commission. So it costs the county commissions more expenses for Mr. Tennant. So it costs my client time to do his operations. It's going to affect you guys as well. We would have to start over from scratch if we just adopted what we have today. Some of the overarching themes, and I don't want to get into specifics, I respect the procedure we're here today, but the fees, for instance, they're just completely unreasonable. The way it's drafted now, you could pay $100,000 for a floodplain permit fee. If you violate the permit two other times, you could pay up to $300,000 for a floodplain permit fee. And while that may seem acceptable to some people, it's just flat out unconstitutional. The fee must be related, when you adopt an ordinance, such as related to the costs associated with processing the permit. To the extent it is not, it will be ruled unconstitutional, and there would be a challenge. You can't just pick a number, it has to be some relation to it. With respect to expenses, well, let me back up to fees in general. We appreciate the fact that there should be fees. I think the fee schedule, although it's vague, and I'll talk about that later in specific comments, we're agreeable to a $1,000 permit fee for a well pad. We have no objection to that. In fact, our proposal would be $100 for a residential development, $1,000 for a commercial development, flat fees. Everybody knows. Mr. Wellings, if he's going to have to do this schedule and try to figure out the math on that, I literally had to break out a calculator to see if I did a $10 million development, what the fee would be. That's just going to create more problems. With respect to expenses, we have no problem with some of the expense allocations. Service fees, publication fees. We suggested ways you should serve and publicize it to people, so we're obviously willing to pay for it. Some of the other things, such as consultants and attorneys, with all due respect to Mr. Tennant, we have an issue with some of that. And I'll get into that specifics later, but we don't know what those are going to be at the time of the application. We don't even know if they're necessary. We don't know how far they're going to go. I don't know what Don Tennant charges an hourly rate. But we're agreeable to pay reasonable fees and expenses for this process. We want to work with the county on that. Another overarching issue we have is the time periods in the ordinance. It's unclear to me after reading it. I probably read it as many times as Donna, 10 times at least, how long it takes from if I filed an application today to get a permit, to get a drilling permit in a floodplain permit. If there's a challenge and it's appealed to the appeals board, there's no time period for an appeals board to issue a ruling. Just to get to that point, it could take up to 200 days from the date that you apply. We only have 180 days to get started if you get a permit. There needs to be more concise time periods. And I understand if there's contests, and I understand if there are appeals, and make sure there's appropriate time frames, and I'll have some suggestions later when we get to specific comments. Regarding engineering studies and floodplain studies and reports, I understand when there are instances when that may be needed. If my client goes out to a situation and does a floodplain study, submits it to Mr. Wellings, no one contests it. There's no need for Mr. Wellings to go hire another engineer to do the same stamp on it, certify it, as long as it's properly certified by a licensed professional engineer. That's a waste of time, money, resources, and it's just not necessary. It's unreasonable. One of the other major issues in the ordinance is there's various standards, and I'll get to some of these. I have all of my comments, and I have the page numbers for them if you want to get to those. We can go through those. There's a phrase called the reasonably safe from flooding, and I understand that, but as lawyers know, reasonable becomes a vague term. We prefer the bright line test of 1 foot increase in the base flood elevation. Many times that may work against EQT and gas drilling. But the reality of it is if you have a bright line test, everyone knows what rule you're playing by. When engineering does this report, whether Mr. Wellings does it or someone else, if it's a bright line, they know. That takes reasonableness out of Mr. Wellings. I've met Mr. Wellings, I've talked to him many times. He seems like a reasonable man, but that's just only going to generate more litigation. We don't want to come to Doddridge County and fight every time there's an issue with our floodplain permits. I want to make that clear. We do not want to come and fight every time we come to Doddridge County over a floodplain permit.
You just want what you want for your client. And
Finally, with all due respect, you'll get your chance, man. But finally, there's one other issue before we get to, just again to thank you. The scope of the ordinance as drafted exceeds the authority to enact the statute. And let me tell you what that means. As drafted, it's in there twice, and I'll point out specific for you later. The floodplain ordinance is applicable if I'm going to do it on top of the mountain outside of the floodplain. Any development. I want to build a hunting cabin up on top of a mountain somewhere. Technically, I would have to come to Mr. Wellings and have him do a floodplain permit application, pay for it, which could be an unknown amount with expenses for review, and then when he tells me it's not in the floodplain, I don't get all my money back. I only get 80% back. That is beyond your jurisdiction. Your authority is to regulate the floodplain. You don't get to regulate anything outside the floodplain. So you need to keep that in mind. Again, proposed ordinance invites many subjective components to a process which should be objective. Your job is to make sure that people are complying with requirements that FEMA is sending down to Kevin Snead to you as your technical advisor. If someone complies with the technical requirements of the ordinance, they should get the permit. It does not matter if it's oil and gas. It does not matter if it's a coal silo. It does not matter if it's a barn, a farm, or whatever. There are some absurd results which are appearing in this ordinance. And I'll get to it, but an absurd result of this ordinance is you can't store hay in the floodplain. Surely we're not intending that to be the case. But that's the way it's drafted. And so while I respect the fact that FEMA wants to get this pushed through, and I respect the fact that we need to get something good on the books, we need to make sure we're taking time and doing it right. Because if not, we're going to be back here again. Again, I appreciate it. I'll have specific comments, and I'm sure we'll have responses to some comments that other people make. And again, I thank you guys all for having us. Thank you.